Okay, thank you very much for coming, everyone. Today, I'm Chris Smith from the Intellectual Property Office. So what does intellectual property mean? I'm judging by the fact that there's not many people sat down here today, meaning we don't actually entirely know what intellectual property covers. If I mention copyright and trademarks, you might have a few people who go, actually, wait, hang on a minute, that's quite important to our business area. That is what intellectual property rights are. They cover copyright, they cover trademarks, they also cover what's called patent rights and design rights in the UK as well. And we are the registry office for those rights in the UK. Government organisation, as demonstrated by the lovely symbol up there. You'll notice it's quite similar to the UKTI one. So we are a partner organisation there. So yeah, I am Chris from the Intellectual Property Office. Just a quick quiz for the few people sat down. Have you heard of the IPO? Yes, yes. Maybe not, maybe so. We previously were known as the Patent Office or the Patent Office, but we did rebrand. The reason for this rebrand was so that we could establish the fact that we deal with copyright, trademarks, designs, and patents as well. Okay, so these are all valuable assets of intellectual property. You might say not the most fantastic rebranding ever, because an awful lot of the people haven't the faintest idea who we are anymore, so good job to us. Well done. So what is intellectual property? It's an umbrella term for the various rights. So a patent being an invention, how things work, what they do, why they do it, and such like that. You've got trademarks for a brand name, company logo, anything that distinguishes a business from one area to another. You've got registered designs or unregistered design protection for the aesthetic look of a product, be it the clothes on your back, a cuddly toy, for example, the way a product looks, not necessarily what it does, but how it looks. It's kind of the opposite right to what you call a patent right, where the patent is how the product works, the design is how it looks. And copyright. Copyright is everywhere in the world, everywhere in your business. Incredibly an important area, especially for the industries here today. Film, TV, photographs, all covered by copyright protection, but also websites, databases. Logos are covered by both trademarks and potentially copyright protection as well. So it's an incredibly important area of IP to be aware of and understand who owns it and where it applies. Confidentiality agreements, incredibly important. Again, if you're pitching to investors or to potential interested parties, you might want to use an NDA or a confidentiality agreement in order to protect you and prevent the ideas that you're expressing to be protected, prevented from being disclosed to anyone else. Okay, so an NDA, a confidentiality agreement, is going to protect you in this case. You've got trade secrets, things like recipes for drinks, for cakes, all protected by intellectual property rights. Under a trade secret, it's not protected by a patent, trademark, design, or copyright protection. Some of these things, such as the iron brew, the recipe for making iron brew, is protected purely by a trade secret, allegedly one of the best in the world at the moment. Anyway, allegedly, only about 2 people in the world know the recipe, and they're both locked up in some sort of cave in the Highlands somewhere up in Scotland. Whether or not you believe that is another matter of fact. Plant varieties. Okay, plant varieties is another area of intellectual property rights available to you, but not actually dealt with by the IPO. It's dealt with by a separate organisation called DEFRA, based in Cambridge. So what is the wonderful world of trademarks, and what does it mean to you? Your company name, company logo, as we've already said, these are protected by trademark protection. Okay, you might say to me, Chris, but I've registered at Company's House, my name's protected. No, it's not. Just because you've registered at Company's House, just because you've registered your domain name, does not mean you have protection for that name and are able to actually trade using it in the UK. A trademark is what gives you those rights. Okay? It must be distinguishing from one business area to another. So if you're called London Web Designers, and your web design is based in London, that is not what we consider to be a fantastic trademark, because that is saying exactly what you do and exactly where you're based. Okay? It is able to be a registered and unregistered right. So if you want to register it in the UK, you can file an application with the IPO, and it will cost you £170 plus £50 per area of goods on top of the first, because it is a trademark. It's a right to trade in a certain area of business in a certain country. Okay, that would only cover you in the UK. If you're wanting to take your IP abroad, so you're wanting to take your business, your whatever the business is, to an area externally, be it Europe, America, Australia, wherever it is, even China, you must protect it in those relevant areas, be it a registered trademark. Okay? You can protect a European registered trademark through OHIM, which is the Office of Harmonization for the Internal Market. Okay, and that will cover 28 countries, including the UK in it. Okay, so consider your trademark, your name, your logo. It's not just those 2 areas, though. You can have anything that represents your business. We've had shapes. The Toblerone have the tubular triangular bar of chocolate as a registered trademark. You will not see any other company producing this same shaped bar of chocolate. That would be infringing Toblerone's trademark. We've even got this. Who do we think owns that? Shops, Asda. Slapping your back pocket twice is a registered trademark for Asda. No other shopping shop can use that gesture to advertise their products. Okay, I do have to make it perfectly clear now, that is slapping your own back pocket twice. Don't think that just because the IPO and the government has said it's a registered trademark, it does not mean you can go around the show slapping everyone's bums and said it's okay, it's a registered trademark. IPO said I could do it. That's not true. It is Asda's registered trademark, okay? The wonderful world of copyright, incredibly important in this industry today. It covers a massive variety of things. These are the various sections for it. So literary works, dramatic, musical, artistic, films, sound recordings, and broadcast and published editions. The 8 areas of copyright that can be protected. And as you can imagine, this covers a vast array of different products and services that you're creating. The important lessons to learn with copyright: it's an automatic right. And it's a universal right. It is covered by the Berne Convention and the Universal Copyright Convention, as well as the TRIPS Agreement. Okay? These all mean, essentially, as soon as you create it, as soon as you press that shutter on on your camera, that photograph is protected by copyright internationally in every single country out there. However, what this does mean is, as it's an unofficial, unregistered right, sorry, not unofficial, unregistered right, it means that you must be able to prove that you created it, and when you created it. So you must date stamp it. You must be able to say, look, this is mine, I created it on that certain date. How are you going to do this? Some methods are emailing it to yourself, sending it to yourself via recorded delivery. If you do this, you might want to lodge it with a solicitor, a bank manager, or other professional that's not related to you. You can sign an unofficial register online. Okay, this is just the UK. It is an international automatic right. The US, for example, however, do have a registry office for if you're wanting to litigate your copyright. So if you want to go to court and take it on further than that. But the laws on this are generally the same across the world. However, with every form of IP, there may be some slight variation from country to country. So depending on where you're going, it is important to keep a track of what is protected, what is covered. Copyright, again, is created and protected and owned by the first creator or author. If you're hiring a cameraman in to create a video of your production, your theatre, your script, that cameraman will own the copyright in that production, in that works, because he created it. Just like if you employ a writer to write a certain script for you, for your TV show or your film, that writer owns the copyright in that script, unless there's an assignment of copyright agreement stating the contrary. The only exception to this is when you've employed someone to do it. So you pay their national insurance as a basic test for this. If you pay their national insurance, they are your employee, therefore you will own the copyright that they create in their ordinary course of employment. Okay, interesting case in that was back in the day, there was Prince Charles, I think he came in one day with a lovely new set of tweeds on, went into his estate, wanted to get a photo taken of him with his lovely set of tweeds. He couldn't find the estate photographer. So instead he went to Caroline Robb, the executive chef at the time, handed her a camera and said, "Can you take a photo of us, please?" She said, "Yeah, that's fine." Took the camera, snap, handed it back. Okay? They used this on all sorts of products, be it stamps, other advertising materials. Later on, Caroline Robb left the employment of the prince and produced a book, Recipes with the Prince, and used this very same photo on the front cover. The prince's estate took a copyright infringement action against her, said, "You're infringing our copyright, you were employed by us when you took that photo. Therefore, we own that." Caroline Robb did her homework and said, "Actually, no, you're wrong. I wasn't employed as a photographer, I was employed as a chef. Therefore, when I created that photo for you, it was actually my copyright. Which what that means is actually you owe me royalties for the use of it on that stamp and other advertising materials." And she won the case, and she was awarded royalties of a few £1,000s, I think it was, in the end. But it just raises the awareness. It's not necessarily yours. Unless you have an assignment of copyright or an agreement in a contract stating who owns that copyright in whatever it is you're producing, you may not own it, even if you directed it. or had the idea, the initial concept. Okay, you will always have moral rights if you created it as to how it's used. So the objection of it being used in immoral terms, if you don't agree with the political party it's affiliated with, or the right to be named as author is always yours. In general, your copyright will last up to 70 years after the death of the author. Okay, as a general rule of thumb. In films, it's a combination of the last of the director, the composer of the score, author of the screenplay, and the scriptwriter. All of these will be involved in that 70-year period. In sound recordings, this used to be 50 years, but as of last November, this got extended to 70 years from first recording. Okay, anyone know why? It's Cliff Richard is the answer to that one. He argued back about a few months ago, a while ago, that actually it used to be 50 years. This isn't long enough. Why should I only have 50 years protection when everyone has 70 years after the death of the author? This is grossly unfair. I want this extended to 100 years. So at the IPO, we had a bit of a conundrum. We had to decide, if we extended this to 100 years, you're going to hear less Cliff, because you have to pay to hear him. If we keep it at 50 years, he's now free to play. You're going to hear more Cliff. Can you see the moral conundrum we're in at the moment? Okay, we decided to extend this to 70 years, partly in order of Cliff, but also partly to keep in line with European convention. Okay, so it's a kind of European right. Okay, TV and radio broadcasts is 50 years from first broadcasts, and publishers' rights is 25 years from creation. But as a general rule of thumb, you're talking about 70 years after the death of the author. Oh. See in a circle, mark your work. You don't have to mark your work. As soon as copyright is created, as we discussed earlier, it is automatically protected for you. You must be able to prove it's yours, and it is a very good idea to mark it. The see in a circle is the generally used term. It is not a legal term to use. You do not need it in the UK. Certain countries do require it, though, so it is a good idea to put it there. It also raises awareness to people out there and says, look, this is copyright protected. You cannot use this without my permission. So please do use the C in a circle if you can. The wonderful world of registered design. It protects the shape or configuration of a product, 3D image, the pattern or ornamentation, a 2D image. It's a regional right if you register it, and there are unregistered rights. You don't necessarily have to register it to have protection. But like we said, you can register it for a stronger protection, much like that of trademarks. A patent or a patent protects the technological function of how a product works. Okay? It must be new, not done anywhere else in the world prior to filing. It must be inventive. What's the difference between your product and the next nearest product? Is it obvious to do that, or is it actually quite a clever step? Okay, so it's got to be a technical effect, remember. It's got to do something. It's not the way a product looks or the new way of teaching something necessarily, but it's a new inventive concept. It must be registered, and it is a regional right. So if you're wanting to protect this patent or the invention across internationally, you must register it in the relevant offices. The IPO being the one for Europe, for the UK, sorry. EPO being the one for Europe, and other national offices across there. If you do not register it, you do not have any protection. If you're taking your IP abroad, like we've mentioned already, in Europe, with a patent, you must go through the EPO, European Patent Office, or you must go through OHIM if you want to protect your trademark or your design protection. Internationally, there is the WIPO, the International Office, World Intellectual Property Office. And alternatively, if you want to go nationally in independent countries, you must go through each office separately. If you want to find a relevant office for your area that you're wanting to look at, go to WIPO directory. You can either Google it or you can go directly through this link there. Okay, and that will find the relevant office for you in that relevant country. So they might be able to help you out with relevant issues that you have in that country as well, such as copyright issues. You can get further advice. If you are going abroad with your IP, it is a strongly recommended idea to, with patents, use a patent attorney through SEPA. With trademarks, use ITMA, or the Institute of Trademark Attorneys. Law Society can help you with other areas of intellectual property rights. If you're looking at copyright, you might want to get in contact with the Law Society, because they will have a better understanding of how copyright applies, for example, in the US, in China, what you need to be thinking about when you're going there. There is a bundle of IPR help desks that you can use, or IPR SME help desks, that will help you access different areas of the world, such as China. There is a Chinese-specific help desk that you can use if you're looking at China, because we're aware it is quite a contentious area. A lot of people say, ooh, there's not much point. They are getting much better, but please use the China help desk to help you move into that industry. That's a European help desk to help you, okay? This is our website, ipo.gov.uk, with a helpline number 0300 300 2000. If you have any queries regarding IP after today, more than welcome to phone our helpline number, or alternatively use our information at ipo.gov.uk website to answer any queries that you have. The website as well, bunch of information on there, including events that we're at, but also if you want to find out more about copyright, trademark, any of those areas, or you want to register your rights, please visit this website and do so as well. There's further advice and available for you, free to download, through our IP for Business tools that you can use online. Pretty much all of these are free. The only one that might not be is IP Masterclass Online, which we're currently looking at the moment. But it's a good idea to use these to help establish your understanding. The IP health check, for example, if you're looking at a trademark abroad, it has got a specific health check designed for trademarks overseas. It's a list of questions. Based on your answers, it will give you a confidential report as to what you should be thinking of doing next.